we need to know common pitfalls and how to avoid them. So first of all, you should avoid filing the application too late. So an example is, let's say you came up with an idea and then you start talking to your contractors and your vendors to make the product, and then you also talk to investors. Now, in general, investors do not sign confidentiality agreements. So if you talk to them, that's basically a public disclosure. And let's say if you put your ideas on your website, that is a type of public disclosure that can come back and be used as prior art against your own application if you file too late. For example, if you file this outside of the 1 year grace period in the United States. In international countries, the mere fact that you have your, let's say, website or your Kickstarter description of your patent, of your invention before you file a patent, that will in fact be a bar to your own patenting activity. So file as soon as you can. The next pitfall is poor documentation. So the importance, a patent application is only as good as the details behind it. So in computer language, we call that GIGO, garbage in, garbage out. You need to have high quality disclosure of how your system works, preferably at least 30 to 50 pages of description and at least 10 to 20 diagrams, right? So what's the advantage of the high quality documentation is that number one, your first application tends to be the fundamental patent application that you will need to keep alive and tweak it over over its life, the 20-year life. To track, let's say, changes in your competitors' behavior, and so the more details you put into the application, the more range you have to adjust your the claims in your continuation application. And so how do we handle that? You can do that if you're experienced, but if you've never done an application, we would recommend that you use software that can guide you through the process of documenting your invention in a structured manner. So consider software such as PowerPatent, where it's a proven way to generate high quality patent application. And it acts as a co-pilot to guide you in putting in the proper structure, so that once you've done that, then you can send this to your lawyer, and then they can finalize it and file it for you at a significant discount. And so the use of PowerPatent can save you money. So another pitfall is you neglect international protection. Now, we recommend that if you consider international protection very carefully, because the cost can mount quickly. So what you should do is analyze what products you have, where is it likely to be commercialized. So let's say if it's going to be a product that's used exclusively in Canada, I would do the US and Canadian patents. Or if you decide that your product's going to be sold in Japan, do those specific countries, because each of those countries, the cost can mount. One cheap way to handle this is use the PCT, or Patent Cooperation Treaty process, where you can defer the decision to go international by up to 30 months from the very first priority date that you claim. So let's say if you file a provisional this year, and you would have, and if you file a PCT within the 1 year period of international filing, you can have delay your international filing deadline by up to 30 months from the date of your provisional application. So that's an example. And then there's another common pitfall is you ignore the freedom to operate analysis. Oftentimes people come up with a product, but then they don't search on how on the competitor's IP to see if there's any risk. And if you're aware of the IP, you can possibly design your products around a competitor's patent that blocks you from implementing that particular feature. But if you know this in advance, you can do that, and it'll be a lot less expensive. So the key takeaway for you here is to be aware and take proactive measures to protect your own IP, as well as to respect other people's IP. So next, let's talk about aligning your intellectual property with different company growth stages. Such alignment is crucial for maximizing value and protecting your IP assets. And we will discuss a general overview of how to approach IP at each stage of your startup. The first stage is you're in the seed, early stage, or pre-series A stage. What you should do is focus on your core innovation, identify and protect the core technologies or innovations critical to your value proposition. You should build a foundation, lay the groundwork for a robust IP strategy by filing provisional patent applications and securing essential trademarks. You can also leverage your trade secrets. Prioritize confidentiality to protect valuable trade secrets, such as how you train your AI, such as your potential customer list, such as your plans to enter the market. Those are trade secrets that can be protected with the proper measures. Next, we'll talk about Series A. At the Series A, where you have more resources, you should strengthen your portfolio. Develop a comprehensive IP portfolio by converting the provisional patent applications into non-provisional ones. Expand the patent filing to cover key aspects of the business. You should expand on your trademark, register trademark for products, services, and brand elements. Align the trademarks with the company's growing market presence. You should also start evaluating your freedom to operate by assessing potential infringement risks and ensure that your products are designed to have freedom to operate in your target markets. Next, we'll talk about what you can do at Series B, fundraising. You need to start thinking about global IP strategy. Expand IP protection internationally and considering the markets where the company plans to grow. And you start filing additional patent applications in these key jurisdictions. We recommend you do this only at Series B because of the cost of international patenting. You also might want to look at strategic licensing. So often a startup will pivot and some of the initial IP assets may be available for licensing because you're not using it anymore. So you should explore licensing opportunities for non-core technologies to generate revenue for the company. You should also monitor your competitors. Implement a robust monitoring system to track and respond for potential infringement so that you can protect your exclusivity and protect your go-to-market strategy. Then at Series C, we should start looking at IP commercialization. You can optimize the commercial value through strategic partnerships, through joint ventures, or licensing agreement. You also look at defensive strategies. You strengthen, you increase your portfolio because now you're at a stage where you might be attracting eyeballs from bigger companies, from your existing competitors who might want to look for ways to push you out of the market because you're becoming now a serious threat. So by building a big patent portfolio, you have a chance to do cross-licensing. Number one. Number two, if you've done your freedom to operate analysis, you should be in a good place to discuss why you don't have an issue with your competitor's IP portfolio. To do this, you also need to do IP audits, and you should periodically conduct IP audits to assess and enhance the overall value of the IP portfolio. Now we're going to talk about Series D and pre-IPO factors. At such a late stage, you need to do IP due diligence more thoroughly. And so having a thorough IP due diligence process, you are now prepared for potential mergers, acquisition, or even an initial public offering. And so you need now to check for legal compliance with IP laws and regulations to mitigate risks during the IPO process. You should also conduct IP valuation, and that's where you can evaluate the company's IP portfolio and articulate its value to investors, particularly in your SEC filing documents. Eventually you will reach the post-IPO, or you're now a publicly traded company. The process you should take there is defensive portfolio management. And this is done by strengthening the defensive aspects of the IP portfolio, particularly in the face of increased visibility and potential litigation risks. You should also encourage your inventors and your developers to do continuous innovation. And this is done by maintaining a proactive approach to innovation and patent filings to stay ahead of competitors. You should also look at your brand protection both domestically and internationally. Your enhanced efforts to protect and enforce the trademark needs to be increased as the brand becomes more of a significant market force. Throughout these stages, it's essentially for all companies to align their IP strategy with the business goals, regularly review and update your patent portfolio, and seek legal counsel to navigate the complexity of the IP system. With this, you will be top of the space with respect to the coordination between your IP strategy and the business strategy execution.